Welcome to another edition of Compliance Solutions, the direct selling show. We're pleased and honored to have our guest on once again. He's a regular on the show. We love him for it. Help me welcome Kevin Grimes. But before you do, let me give you a quick introduction. He is an incredible human being and also an incredible attorney. He's a former distributor, and I think that's why he's such a great attorney. He was with Amway and Nikin. Now he's also with Thompson Burton Law Firm, with Kevin Thompson, a great practice. They're doing incredible things in the industry. And he is, I think, the most experienced and accomplished MLM attorney in America. I've named you that on previous Compliance Solutions show, and I'm sticking to it.
Well,
He's got over 25 years. I think it's even more than that, 25-year career.
We're actually hitting 30.
Oh my gosh, 30-year career.
Started practicing law when I was 2.
You did. And he's represented in the who's who of direct selling companies. He's also the founder of MLM Compliance VT, which I could spend a whole show talking about that. We'll have to do another one. The best compliance education that's available out there in the industry today. Now, he practices consumer protection, food, drug, cosmetic, dietary, supplement law, and distributor compliance. And I'll tell you, he's got the biggest heart you could ever have. He has fostered so many children over the past, I think it's 20 years now, 30 teenage boys, and he stopped counting. So I'll bet you it's more than that. He's also adopted 4 so far, and I'll bet you that's going to increase in the numbers in the future as well. So let me go ahead and give him a quick round of applause because he deserves it. And I'm going to come back to him in just 1 second. I want to introduce myself real fast and tell you a little bit about me. Donna Serritella. I'm the owner of Direct Selling Solutions and the author of Compliance Solutions, also known as the Queen of Compliance. Been in the industry exclusively working since 1991 as an expert compliance officer and resource in the industry. Like I said, we're going to talk about the income disclosure statement. But before I do, and we address the goal and the intention of the call, I want to turn it to Kevin and ask him what's his role today in the industry. But wait, we need another applause because he is just, there we go.
Okay.
So Kevin, if it ever ends, you're getting a standing ovation.
Oh, wow. Well, thank you.
Okay, so before we address our goals and our intentions, tell us about your role in the industry today.
Well, I work almost exclusively with direct selling companies and assisting them on the corporate side with their corporate compliance, as well, as on the distributor side with distributor compliance. In terms of the corporate side, I work with them to make sure that their claims, whether it's about their compensation plan, the income opportunity, or whether it's about their products, are compliant with state and federal law. The same is equally true on the distributor side. Distributors are just as responsible as our companies for ensuring that their claims are legally compliant. And the challenge in this space is there are a lot of things that that are true and substantiated and honest, but just because they're true, substantiatable, and honest doesn't necessarily mean that they can be said, which is incredibly frustrating in this space. And I'm sure we'll probably get into that. But yeah, the bottom line is, is that I'm trying to help companies comply with state and federal laws so that they're able to stay in business.
Fantastic. Well, we're talking today about the IDS, the Income Disclosure Statement, and we have to help distributors, Kevin. This is important. We've got to help them understand the IDS. Even me, as in years of being a compliance expert, it's difficult for me to understand what you can say and you can't say with the IDS. There's certain lines that when you cross them, I still go, oh my gosh, that's not a claim, or that is a claim. Mm-hmm. So we're going to help distributors and the company owners today. We want to speak to the distributors about the importance of the IDS and how to use the IDS, plus why companies must use an IDS. Mm-hmm. So we're going to address direct selling owners and distributors. So listen up if you're an owner or a distributor. And if you know an owner, share this. If you know any distributors, share this information. It is so valuable. Everybody's talking about the IDS right now. So let's get into it, Kevin. What is the income disclosure statement?
So the income disclosure statement is a disclosure document that direct selling companies have to prepare. One of the realities in this industry is that, sure as the sun is going to rise in the east, distributors and companies are going to make income claims. The problem is all income claims, with one very, very narrow exception, are deceptive. And of course, deceptive claims violate state and federal consumer protection laws. The good news is that the deception can be cured with a proper income disclosure statement. Now, so whether I'm making a testimonial about my income, whether I'm talking about some atypical earnings like what our top leaders make, whether I'm making lifestyle claims, pictures of mansions and yachts and private jets and things like that, all of those claims are deceptive because they mislead the reasonable and prudent prospect to believe, hey, everybody makes that kind of money or has that kind of lifestyle, or lots of people in the company do, or most people, or it's easy to earn that income, none of which is true, and hence the deception. The one super narrow category of claim that is not deceptive is statements of average earnings of all distributors. But nobody makes those claims. Moreover, distributors don't have access to the information that's necessary to compute that. Only the company has access to that data. So the income disclosure statement, and it's important to note that all income disclosure statements are not created equally. The federal courts, actually the Federal Trade Commission and the federal courts, have gone back and forth on a couple of cases. And when the dust finally settled, the U.S. Court of Appeals had articulated several different elements for several different categories of income claims that were necessary, several data points that were necessary to disclose in order to cure the potential deception. So a proper income disclosure statement incorporates all of those elements for all of those different types of income claims.
Okay, great definition. Companies are interested to see how the FTC handles these claims with or without the IDS. And then the distributors are using it to vet companies. They look for the IDS as a tool to find out foundational information about the company. So why is it important that the companies are interested to see how the FTC handles these claims? Why is that important?
Well, it became hyper important a couple of months ago. In October of 2021, the Federal Trade Commission sent notices to 1,100 different companies. Now, these were not all MLM companies. They were all companies, different companies in the income opportunity space. So that includes not only direct selling, but affiliate marketing companies. So Amazon, for example, received a notice. It includes gig economy offerors like Uber Eats and DoorDash. They both got notices. It included franchisors. Several of them got notices. And the purpose of the notice was to put these companies and actually entire industries on notice as to what the FTC believes is a deceptive and illegal income claim. And so sending out that notice was the first step in an enforcement strategy called the Penalty Offense Authority. One of the things we also know is that last year, the FTC announced, or the Consumer Protection Division of the FTC announced its top 5 priorities. I don't remember what the other 4 were, but in the top 5 were MLM income claims and MLM product claims. So we don't have to speculate or guess as to whether or not MLM income claims are a big deal to the FTC. They are. They've openly disclosed this, and anybody who doesn't want to believe that is really just sticking their head in the sand. So it is a big deal. It is potentially a bet the farm proposition. I mean, companies could be put out of business for stuff. I don't, that's not fear mongering. That's not Chicken Little, the sky is falling. It's just the truth as to, where the FTC is right now.
Definitely. And the IDS isn't just a standalone document, it's a combination of the whole compliance effort of a company. So combined with solid monitoring, compliance measures, and how the claims are being resolved will satisfy the regulatory requirements and keep the FTC off your back. The IDS isn't going to do it altogether. It's one piece, one tool in the toolbox.
Well, and absolutely, there's several pieces to this puzzle, and another one is educating people, because there's a lot that's really counterintuitive about income claims, and a lot of people don't understand. Gosh, if I really do make $2,000 a month, which is to say, my statement is true, and if I could substantiate it with copies of checks or W-2s or something, or 1099s. I don't understand why it is illegal for me to share truthful, substantiatable information. And the answer is, well, because it's still deceptive for all the reasons I mentioned before, like, it leads prospects to believe everybody makes this, most people make it, or it's easy to make. So, so the kind of the biggest missing piece in all this is educating distributors about what is legal and what's not legal. And so, for example, and this is a dynamic and changing area of law. In its October 2021 notice, the FTC outlined several different categories of claims that it considers, income claims, that it considers to be deceptive. And so companies need to provide this information. They need to educate the field as to, hey, you need to understand that these categories of income claims are deceptive. And this is very significant because the universe of deceptive income claims expanded in October 2021. And the reason for that is previously, as I mentioned earlier, and this was actually several decades ago, that the FTC and the federal courts went back and forth over a couple different cases and hashed out what's necessary to cure potential deception with respect to MLM income claims. But by lumping in MLMs with franchisors, with gig opportunity offerors, with affiliate marketing, it took deceptive income claims from affiliate marketing, deceptive income claims from franchising, deceptive income claims from the gig offerors, and lumped everything together. And so everybody's income claims universe, deceptive income claims universe, expanded. So this is an example of how the law can change, and it's happened very, very recently. Mm-hmm. So yeah, we actually need to get some resources out there to help folks understand. Previously the world of MLM deceptive income claims was like this. Now it's like this.
Wow. And nobody knows.
Not very many people do.
Not very many people. Well, let's talk about the absolute minimum. Mm-hmm. I have a chart that I can show that with every client that I work with, I say, you got to have an IDS, you got to have an IDS. And I show them the income disclosure statement sample. I'm going to pull that up so you can identify. Don't get overwhelmed, viewers. We're not going through every line of this. It is a big document, but what I want to show is the actual document so that people can see that this is really what an income disclosure statement looks like. Can you see it, Kevin?
Yep, I can.
Okay, great. Why don't you share with us a little bit of information about this document?
Sure. So this document is really the product of that case law from the Federal Trade Commission and the federal courts. Like I said, in those couple of cases, specifically on MLM income claims and how to make them non-deceptive. And so again, it's all about, the issue is complete disclosure. How do you cure potential deception? The answer is you provide complete disclosure. So that requires setting forth each rank in the company's compensation plan. It involves setting forth the minimum, maximum, and average compensation for each rank. It involves indicating either the number or the percentage of distributors at each of these ranks. It also requires the company to poll its distributors to find out, how much time they spend, working their business, per week, per month. And then lastly, it needs to include the minimum, maximum, and average length of time it's taken to reach these ranks. Now, all of these numbers, all of this data has to be reported for all distributors. That even includes inactive distributors. And so, if a person is carried on the company's books as a distributor, irrespective of the fact that they've been inactive for the last year or two or three, it doesn't matter. those people have to go into the calculations. Now, in addition, you'll see these blue columns that talk about active distributors. In addition to reporting data for all distributors, the company can also report data for just active distributors. And that's what these blue columns are. And obviously the numbers are going to be higher and better for distributors who are active. Now, outside of that table, you see, 2 paragraphs that have some additional information. For example, it talks about what the average earning, of all distributors was, what the median earning of all distributors was, the percentage of distributors who did not earn anything for the reported year. And you notice, that this income disclosure statement has a date. This one is for 2018. The FTC's requirement is that the data must be timely, and timely is defined as updated not less than annually. So if your company is using a 2018 income disclosure statement or even a 2020 income disclosure statement, that's not good enough because it's not timely. And the danger with using one is that the FTC would be free to disregard it and just treat it as if it doesn't exist. So so those are basically the data points. And the second paragraph also provides a little bit more detail about expenses and again company executives may be watching this and think, good gosh, does that mean we have to poll our distributors? Well, yes, it does. You have to poll them anyway to find out how many hours a week people at each rank are working their business. So you may as well ask them what they believe their expenses have been for the year.
Right. And from what I see, the companies don't want to provide this information because they think that people won't want to join, that the numbers are too low. But the truth is, I've got distributors asking for the IDS. They're familiar with it. And it's so important to the company owners to use this document properly. And we're going to talk about that. What's your experience with people that just don't want to use it?
I would say, number one, tough darts. Number two, grow up. And number three, you have no idea as to the potential liability to which you're exposing your company. Under the FTC's new strategy, the Penalty Offense Authority, it can impose a penalty of over $46,000 per offense. So let me just give you some numbers. Let's say you have a small company, and let's say you've got 10, or let's say you've got 100 active distributors. And each of these 100 active distributors are talking with 10 different prospects per week. So they're making income claims during that. So let's say they're, 10 income claims per week times 100 distributors, that's 1,000 income claims per week. And let's say they do it for 26 weeks. So that's 26,000 income claims. Okay. Again, we're just talking 100 distributors for 6 months. Well, 26,000 deceptive income claims times $46,000 is over $1.1 billion of potential liability. There are not very many companies that could stroke a check for that amount. And again, I'm not trying to be Chicken Little. I'm not trying to fearmonger, but right. So the FTC has loaded the gun when they sent the notice out in October of 2021. And now they are sitting back and they are monitoring all these companies to see what they're doing. And they're just collecting data. Okay. And when they have enough, and I have no idea, whether it's going to be 3 months from now, 6 months from now, 12 months from now, but they're just going to total up. Okay. Company X, you and your people made this many deceptive income claims, enclosed, please find our bill for $2.3 billion. Please remit payment within the next 30 days.
Wow.
Yeah.
There's a lot of liability out there.
There is. The liability's huge. You have $46,000 per offense. Okay. It's not worth risking by not having an income disclosure statement, but it's not enough just to have one. They have to be properly used. But in addition to that, because as I just said, because in October, the universe of deceptive income claims expanded considerably, the field and corporate needs to be educated as to, what does constitute a deceptive income claim? Because one of the IDS is not a panacea. Okay. It's not going to cure every type of deception. The type of deception it cures is deception that arises just from limited information. Okay. So when I say, yes, I make $2,000 a month, it's truthful, it's substantiable, but it's deceptive because it's limited information. But the IDS provides full information and hence cures the deception. On the other hand, there's certain types of income claims that are just patently deceptive and can't be cured even with an income disclosure statement. So let's say, for example, in my company, the highest income earner makes, $2 million a year. If I'm out there saying, yeah, our top earners make over $10 million a year, that's just a lie. Okay.
Mhm.
It's not only deceptive, but it's not true. And an income disclosure statement is not going to cure that.
Mhm. Okay, great. Now, from a distributor's perspective, how in the heck do you use this page of information?
Sure. Well, again, even before you're talking with a prospect, you really need to find out what exactly are all these different categories of claims that the FTC says are deceptive, so that you're not making those claims. But again, I want to make sure that folks understand that truthful, non-deceptive income claims are perfectly legal. So, folks need to understand how to make truthful, non-deceptive income claims. And then when they're making those claims, of course, the income disclosure statement needs to be provided to every single prospect. So whether you're doing a one-on-one, whether you're doing a home meeting, whether you're doing a huge venue, every single prospect needs to receive the income disclosure statement. Now, a lot of times people will say, well, can't we just flash up a QR code and have people take a picture of that with their phones? And I would say that's a nice addition, but that should not be the primary means of disclosure. The primary means should be paper, hard copy. I'm not a tree killer, okay, but the problem is, hey, everybody may not have a phone at a particular meeting, or
Mhm, mhm,
maybe they don't have a QR code reader, or who knows,
mhm,
whatever. But we can't rely 100% on technology. So the easy solution is, look, the income disclosure statement is a one-page document. Print
mhm,
it out and make sure that every single prospect gets one.
absolutely. I've been at one company, I've been involved in the industry since back in 1991. I've been
Mhm.
at one meeting, one business opportunity meeting, where they had a pad of paper full of IDS, and they just pulled them off. When you walked in the door, you got handed an IDS. I didn't understand it. I didn't know how important it was. I took it, looked at it, and said, that's nice. But, is it okay if it's online, if it's digital? Is it okay to use a link? Because we're not going to be handing them a piece of paper. Does a link suffice?
It's really not the ideal situation. Again, that's an adjunct, just like a QR code, because again, some smart person may not be surgically attached to their cell phone. Okay. And they may not write down the URL. By providing them with a paper copy, that satisfies the disclosure requirements, and it eliminates all the potential pitfalls or excuses that can arise via an electronic communication.
But if you are in a social media setting and you're
Mhm.
online, would you then show the document? You show the link or you show the document? How would you be able to adjust that?
Yeah. Well, I would say, part of the answer may swing on the hinges of whether, it's a live presentation or whether it's a
Oh,
recorded presentation. And so, ideally, you're not going to flash up the full income disclosure statement every time you make an income claim, but there needs to be a pointer, and I'll define what that is in a second, that alerts viewers to the fact that, hey, we are going to be providing, complete information about the income opportunity, in the income disclosure statement. So for example, every time an income claim is made in that presentation, there's a pointer that flashes up on the screen in clear and conspicuous type that says, important information, or notice, or, attention, please see the end of this presentation for important and complete information regarding the entire company X income opportunity. Um,
okay.
so it lets readers know, it's like, oh, there's more information, and it's important information at the end of this.
Okay, I understand. So what are some mistakes that you see distributors and companies make? Where do they go wrong besides, I know, not completing this income disclosure statement with the minimum, the absolute minimum? The companies make up stuff or they transition stuff to make it look better. So
Yeah.
what are some other mistakes that the companies make besides altering the income disclosure statement so it looks nice?
Yeah. Well, let me just touch on that because everybody needs to understand that the income disclosure statement is not a sales and marketing exercise. I understand that the legal tail should not usually wag the business dog, but this is one instance in which it absolutely must. This is exclusively a legal and regulatory exercise. Sales and marketing has no place in this. This is not about spinning information. This is not so everything that's in there has to be disclosed. I've seen very, very large companies omit. They didn't attempt. They omitted some of the required information, and they got nailed
Mm,
for it. So everything that's in there it's there because it needs to be there. Again, this body of case law has said, hey, this is what's necessary. So that's a big mistake, is not including everything that's required.
okay. Some other mistakes as far as how the distributors don't use it. I see that out there all the time.
Yeah, absolutely. Because, hey, as a company, you can have the best income disclosure statement in the world. But if you or the field are not using it, then regulators and courts, rightly so, will treat it as if it doesn't exist. And so, boom, now you're right back to making deceptive income claims. And this is super low hanging fruit for the
Mhm.
regulators because everybody makes income claims. And so, the starting position with all this is all of these income claims, all of this activity, all these income claims are deceptive. All of this activity is illegal unless, number one, they're making non-deceptive claims that are outside of those categories the FTC articulated in its notice, and they're providing copies of the income disclosure statement to every single prospect, or making sure that every single prospect is alerted to the availability of the income disclosure statement.
Okay. So what I'm hearing is that companies shouldn't make blanket statements and think the IDS is the ultimate solution because
Mm-hmm.
it's going to work every time.
Right.
And we know it doesn't. So the ordinary rules for claims apply even with the IDS.
Right.
And
Yeah.
it won't work to offset the claims like you just explained. It just helps make ordinary claims acceptable.
Mm-hmm. Right.
Okay. So if a reasonable person looks at the claim and says, and sees, I make $1 million and it's not legal, it's not the truth, can that
Mhm.
trigger an FTC scrutiny? Or what do you think? One or two or five of these? What will trigger FTC scrutiny?
It doesn't take a lot, that's for
Mm,
sure. In fact, several years ago, and this really wasn't primarily about income claims, but uh, gosh, I want to say around 2004, I think the Federal Trade Commission sued a company called Trek Alliance. And while the company took issue with some of the things that the company was doing, I would say 80% of the FTC's issues, as articulated in their complaint, were a function of what the company's leaders were doing. And the number of leaders that it mentioned it was about 7 or 8 leaders.
wow.
That was it.
Wow.
It wasn't dozens. It wasn't hundreds. It was less than 10 leaders that got the company in the FTC's gun sights.
Mhm. So both distributors and companies must think about the claim if it's misleading, or I hear this all the time, the net impression, the
Mm-hmm.
repeated net impression is misleading. Can you talk
Mm-hmm.
about net impression a little bit?
Yeah. So, I mean, yeah, that's a really fundamental tenet of advertising law, whether we're talking about, FDA related product claims, whether we're talking about, FTC related claims. And so, yeah, it's a function of the totalities. It would be easier to talk about product claims. So let's say, for example, that we have a great dietary supplement product, and we're making a lot of proper structure function claims, but there are also some implied claims about preventing or curing or treating or mitigating a disease. Or let's say here's how it also comes in is like, let's say we do a Facebook Live together and all of our claims are proper, but throughout other places on our social media websites, we're making improper claims. And so the regulators, aren't just going to look at this one piece to the exclusion of everything else. They're going to look at, hey, in the totality of your website, in the totality of your social media page, you're making claims, A, B, C, D, E, F, G.
Okay. So the claims that this is the thing that gets me. You've got a claim, let's say, I made $15,000 last month,
Mhm.
and it's the truth.
Mhm.
Since it's the truth, is it deceptive?
Well, yes, without the income disclosure statement, it
Without
would
the
be
income
deceptive.
disclosure statement. Okay, so if you have the IDS, that takes away the sting of saying, I made $15,000 last month.
Mhm.
And you can say that with the IDS.
Right.
If it's
Correct.
true,
Right.
it's
Yeah.
got to be true.
And you could substantiate it. So, presumably you can substantiate it. You've got the records to do that.
Verifiable evidence that it's true.
Mhm.
It's when it's outrageous and over the top that the IDS isn't going to help.
Yeah. Like I said, in my earlier example, top income earner makes 2, and you're out there saying, our top leaders make 10. That's dishonest. Another area that the FTC's got a lot of heartburn about are lifestyle claims, pictures of, mansions and yachts and jets and, exotic trips and all that. That is just a real thorn in their side. And so, a lot of companies need to make some decisions about, whether they want to continue to go down that road, which I don't recommend at all. Just at least for now, get rid of lifestyle claims altogether. It's just really, really, really dangerous.
Altogether?
Mm-hmm.
Can they? I've got a client right now. They went on a trip to Mexico, and they're showing the trip to Mexico,
Mm-hmm.
and they're showing the leaders. They're showing the leaders having fun in the pool, just having fun. Now,
Right.
when it's a is that a lifestyle claim when you're on a trip about the company and all you want to do is put some pictures up on Facebook? Would those be considered lifestyle claims?
Well, again, it depends upon the overall net context and content, of the page. So, for example, I've got a personal Facebook page and I've got a professional Facebook page, and a lot of distributors do the same thing. Here's my personal
Right.
page. Here's my company X Facebook page or Instagram or something like that. And so there's a little bit of a division in the law as to, what you can do on a personal page versus what you can do on, kind of a business page.
Mhm.
If, yeah, I mean, on my personal Facebook page, I've got, pictures of vacations and here's the kids and here's what we're doing and, yada, yada, yada. And I'm not talking anything about business.
Mhm.
It would be pretty difficult to contend, that's even an income claim. It's like, hey, look at my pictures of the Grand Canyon or Yellowstone National Park or
Mhm.
whatever, in addition, hey, I went on this trip with the company.
Right, right. And the trips with the company, they have such grandiose prizes, and
Mm-hmm.
they're going on yachts to see such and such, or they're going off with the whole team on a bus to visit the ruins or whatever
Right.
they're doing. It's so phenomenal that you almost think, is this true? And
Mm-hmm.
then they're, possibly showing off money, showing off jewelry, the whole 9 yards. These lifestyle claims are out there. When we monitor for them, we're not that particular about lifestyle claims, but maybe we better be. From what I'm hearing you say, your preference is not to have those big extravagant lifestyle claims on your business page for the particular company,
Mm-hmm.
or on the company's page, because I've seen them on companies' pages too, where they'll
Yeah.
have the whole trip mapped out with the 14 people that won the trip.
Mm-hmm.
Those things can be problematic.
They certainly have the potential to be. And, the challenge is that, as I said, in October 2021, the law expanded substantially with respect to deceptive income claims. So, to a certain extent, we're all kind of sailing in some uncharted water here.
Mhm.
But if you look at, recent FTC enforcement actions, you see them really teeing off on lifestyle income claims. For example, in the FTC versus Herbalife complaint from 2015,
Mhm.
that was a big issue. I think it might have been also in the FTC versus VEMA, but I don't recall. And so it's like, you know, if you're the CEO, do you really want to take the chance that, to put your company on the potential receiving end of, of the penalty offense authority and
Mhm.
its, debilitating potential liability? And so, a paradigm shift that we need to make in the industry is we've got to tone it way down with
Mm.
respect to income claims.
Mhm.
Um, there've been other seismic shifts that have occurred in the industry, like, the absolute necessity to have the majority of, company revenues and distributor compensation flowing from sales to customers, bona fide customers who are non-participants in the program. And
Mhm.
historically, the MLM industry has been very slow to accept, legal and regulatory changes. Um, the dinosaurs had the same problem, when the ice age hit. They just didn't have the capacity to adapt, and now they're all extinct. Okay.
Mhm.
And
Mhm.
so in direct selling, it's not that we don't have the ability to adapt. It's just that with a lot of companies, a lot of management, there's not the willingness to adapt. And that is
Mhm.
really going to be dangerous and a tremendous liability in the current age.
Mhm. Mhm. I don't understand. Have any companies actually been hit with the penalty offense authority? Have
No.
there been companies that have
Well,
been fined yet?
do you mean direct selling companies?
Yeah,
No, no.
I didn't think
The,
so.
yeah, the FTC is not there yet. Several years, the FTC first deployed the penalty offense authority, again, not in direct selling, but I want to say maybe mid 70s, mid to late 70s. And they went after the bamboo fabric industry because a lot of folks were marketing, bamboo sheets, bamboo towels that were really made out of rayon. And it was just rampant. And so
Oh.
the FTC, yeah, deployed the penalty offense authority there, put an entire industry on notice. And then it went after several companies and just nailed them to the wall with these massive penalties that it imposed. So like I mentioned, phase one has been accomplished. The FTC's put the income opportunity industry on notice. Now they're in evidence gathering phase. Okay. And they're
Mhm.
watching these companies and they're collecting all the evidence that they can. And they're going to go after the worst actors when they feel that they have enough. And,
Mhm.
it's really sad to say well, gosh, this was in 2004. I was at a conference of the Direct Selling Association, and the FTC's acting director of the Bureau of Consumer Protection was speaking. They were talking about the FTC's relatively recent litigation strategy that was putting MLM companies out of business. The company shut down, asset freeze, appointment of a receiver. And when asked about this strategy, the gentleman from the FTC responded. He said, "Look, our agenda is to put companies out of business with a minimal outlay of federal resources." Again, I don't mean to sound draconian or chicken little or whatever, but that was, his paradigm. And I kind of doubt that paradigm has changed a lot with respect to, who the FTC thinks are bad actors.
Mhm. Mhm. It's not that they're gonna fix it, they're just gonna put them out of business.
Absolutely.
That's
Yeah.
scary. Oh, that's scary. For some owners, they don't accept that that could even be the reality. But if you
Mm-hmm.
look at the size of the fines that they could give for
Mm-hmm.
the major offenses that are out there, we do monitoring, we do digital and manual monitoring. And
Mm-hmm.
when COVID was running crazy with claims,
Right.
we had companies hiring us left and right doing just search for COVID claims. We want to get the COVID claims. And there were tons of COVID claims out there
Mm-hmm.
that their product, mostly CBD, I have to give it to the CBD sellers,
Mm-hmm.
but mostly those CBD companies making outrageous claims. And they're making the claims, and this is really confusing and frustrating to companies and to distributors. The CBD companies make claims based on studies that have been done that may not have the oomph that the study needs to be accepted.
Mhm.
And they make these claims and think it's okay because the study says so.
Mhm.
Now, just because something is in a study and it says it's okay to say this, it's
Mhm.
not okay to say this about nutritional supplements, is it?
Yeah, absolutely. Well, there are always, we're digressing, but we can certainly talk about it. There are always two
Talk about it.
issues when we talk about product claims. Number one is the claim appropriate for the product. So, for example, you know, hemp-related products are, or at least those that are ingested are invariably sold as dietary supplements.
Mhm.
But no one can legally make drug claims for a non-drug product. And so the Food, Drug, and Cosmetic Act defines a drug as articles intended for use in the diagnosis, cure, treatment, prevention, or mitigation of a disease. COVID's, definitely a disease. That's not a debate. And so any claim that talks about curing, preventing, treating, or mitigating COVID is a drug claim. And so what that does is it constitutes an offense called misbranding, which is taking a product in one category, namely dietary supplements, and converting it into another one, namely a drug, without going through the drug approval process. So not only does it involve misbranding, but it involves selling an unapproved new drug, which is another offense. But and aside from that, in addition to, hey, is this claim proper for this category product? The FTC is in there on the issue of substantiation. Okay. And when we talk about claims related to safety or efficacy, those can't be made unless the marketer has adequate substantiation, which is defined as competent and reliable scientific evidence, which is further defined as tests, studies, clinical trials conducted by qualified professionals to yield results generally accepted within the industry, blah, 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 blah.
Mhm.
But a big mistake marketers make is they think all studies are, created equally. They're not. Just because there's a study doesn't mean that it rises to the requisite level of substantiation. There's a big difference between a 10-person, 8-week study and a 50,000 person 5-year study. Okay. But not only that, but there are a lot of other variables in that, hey, was the amount of this particular dietary ingredient in this study the same or very close to that in yours? No, there's a tenfold difference. Again, hey, well, this study was on postmenopausal women over 60, but you're making the claim for the general population. You don't have substantiation for that. So yeah, there are a lot of subtleties involved when it comes to substantiation.
And you have taught me well about substantiation. You can't make that claim unless the company has the substantiation in their hands. That's
Right.
correct, in their hands.
That's exactly right. The substantiation has to be in the company's possession at the time they first start making the claim. The case law is very clear that the FTC and the courts are free to disregard after acquired substantiation.
That's scary because I know in all the clients I've had since 1991, there
Mhm.
is not a lot of substantiation in those offices. We're just now starting to push for that. And now digitally, it's a whole lot easier to pull it in and
Mhm.
have it available. It's just interesting to see that people don't rely on substantiation, and it's so important. So let's talk a little bit about the distributors and how they're responsible for what they say. Owners don't understand that. Distributors don't understand that. And it could potentially cost their company or themselves, if they make inappropriate claims, suspensions, fines, possible termination of their status from the company. So, really, what a distributor says makes a difference. Can you address that for a little bit?
Sure. Yeah, absolutely. Um, you know, most everybody, excuse me, most everybody knows that distributors are independent contractors, excuse me. And that's true in certain legal arenas like the contract law arena or the tort law arena. But in the regulatory arena, distributors are agents of the company. And as an agent, they have the same capacity to incur liability for the company as does the CEO. So the statements of a distributor are the statements of a company.
Period.
So yeah, and so But not only can a distributor's, wrongful statements incur liability for the company, they can incur liability for the distributor. The fact that, a person is a distributor does not insulate him or her from potential regulatory liability. In fact, for many years in enforcement actions against companies, it's not unusual for the regulators to also sue, some of the top distributors, or, whatever distributors are doing things that the regulators believe are improper.
I have seen that, and the distributors are in shock.
Mm-hmm.
They can't imagine that that's the case. All right, we've talked about the IDS. We've talked about how to use it. We've talked about what it encompasses. My intention in the beginning of the call was to make sure that we were helping the distributors and the company owners, which I think we have, speak to the distributors about the importance of the IDS and how to use it, plus what the companies should do. So I think we've had a successful call. We've gone over a lot of information. I would recommend that people go back and listen to this again. It's a great way to fall asleep if you're having a little insomnia. I won't make any claims though, but it is information that is critical to your company. And it's critical if you're a distributor to know this information. And if you're an owner, shame on you if you don't know this information. It is very important to the longevity of your company. So let's think for a minute. Do we have some final thoughts on the IDS, or frankly, anything that you'd like to share with the listeners? We're going to get this out there and share it with as many companies and distributors as we can. So I think we've met our objective. We offered a comprehensive approach to the IDS. What are your final thoughts about this IDS, Kevin?
Well, number one, it is a bet the farm proposition. If companies don't have one, if they don't have a proper one, I mean, their liability is literally through the roof. It could easily be $1 billion very quickly. So it is a bet the farm proposition. But it's a great document. I think it's a very powerful marketing document because with it, companies and distributors are empowered to make truthful, non-deceptive income claims and get the word out about their opportunity. Point number two, as I mentioned earlier, this is not a sales and marketing exercise. So there is no room for massaging the data or trying to spin anything or position anything. It's all about complete disclosure about the income opportunity. Number three, it absolutely needs to be timely. Number four, yes, in addition to, monitoring, like you've talked about, companies need to be monitoring people's income claims. They need to be correcting people who are misstepping. But even before that, they need to be educating people. They need to be educating the field as to, hey, what's okay, what's not okay, and how to properly use the income disclosure statement. So it's not rocket science. It's really, really simple stuff. But like the dinosaurs, companies and entrepreneurs and leaders are not willing to adapt to the new climate. I'm concerned are going to go the same way as the dinosaurs.
Well, direct selling does not want to go the same way as dinosaurs. And if we don't do something about it and educate people, it might just happen, because there's some haters out there that would like this industry to go away forever.
Absolutely.
So I appreciate the final thoughts. We've met our objective. I thank you for another exciting edition of Compliance Solutions, the show.
So exciting.
Oh, it's so exciting. Wait until the masses hit my YouTube, which I was going to remind the listeners. On YouTube, you and I have Compliance Solutions about, are you making a drug claim? And it's a wonderful representation about making drug claims. So if anybody's not clear on whether they are making a drug claim, listen to Kevin and mine, Compliance Solutions, and it's highlighted as, are you making a drug claim? So that would be an important one to catch wind of. It's on the Direct Selling Solutions YouTube channel. Anyway, where can people find you, Kevin?
Well, they can find me on our law firm website. It's just thompsonburton.com. There's a pull down menu for the attorneys, and my happy shiny face is on there, so they can certainly find me there. They can also find me at mlmcompliancevt.com. VT is in virtual training. Um, check that out. It's not set up right now for individuals to use, but if companies are interested, certainly happy to have a conversation with them about that. And this, it's interesting, compliance training is the next big thing that the regulators are after. We've seen state and federal regulators cramming distributor compliance training programs down companies' throats. The FTC versus Herbalife
Mhm.
case was a good example of that. And companies, again, really need to pull their heads out of their backsides about compliance training.
Mhm.
It's unfortunate because I think the vast majority of leadership in this industry it's like, ooh, gosh, we don't want to do that. We don't want to educate our people about legal and regulatory stuff. But again, the failure to do so just is presenting some incredible and increasing risk to the company, because regulators are expecting companies to see it. They know that companies provide a tremendous amount of information and education to companies already. Information about the products, information about how to sell the products, the opportunity, recruiting, leadership, whatever, because it's so easy now to provide all this information to folks. And in the minds of the regulators and also the courts, the thing is, it's like, wow, if I'm running an MLM company, how can I make the argument that I'm a good corporate citizen? I provide 35 hours of, training to my field, but not 2 seconds of information about how to operate your business in a compliant fashion. And that's really the threshold issue for the regulators and the courts. Is like, what am I dealing with here? Am I dealing with, a company that's just inadvertently and unknowingly misstep, but it's really a good corporate citizen? Or am I dealing with a slime ball that needs to be
Mhm.
put out of business? And, I want to be careful in using those terms, but again, a lot of regulators have a pretty jaundiced worldview, particularly when it comes to MLM. And so as an industry, we really need to be thinking and speaking and living best practices, not, hey, what can I get by with? Not a nudge, nudge, wink, wink approach to compliance. Not only just good faith compliance efforts, but absolute thermonuclear, scorched earth best practices. That's where companies need to be. And that's why compliance training is so critically important.
It is. And not to spend too much time on it, but I have to share with you, compliance training has come so far. When I first got involved in the industry, it was a piece of paper that a company might show a distributor in a leadership event or something or other. It was nothing.
Mhm.
Now we're getting inquiries for PowerPoint presentations, and companies are asking about randomized testing for compliance training.
Mhm.
MLM Compliance VT has all of that. So if you're looking to get some education for your representatives and for your team, I love compliance, MLM Compliance VT for the owners and the compliance staff. They should be taking it and knowing and becoming familiar with it. So
Mhm.
there's great ways to use it for those owners out there that aren't doing any compliance education. You really need to reach out about MLM Compliance VT, because that's a great step in doing it the right way with randomized testing and all of the things that the regulators are looking for in compliance education. Anything else you want to add about compliance
Well,
education?
I think, as you used to say, from your swamp buggy racing days, shut her down, Luther. She's sucking mud. So
Well,
I'm
let me
done.
say, you can find me at Direct Selling Solutions, and you can find me as the Queen of Compliance. Oh, my crown's not going on straight. And you have to know that the Queen is always watching. So be aware. There's going to be another compliance solutions show on soon. And this one is, as they say, on the books. Thanks, Kevin. We appreciate you very much.
My pleasure, Donna Marie. Thank you.